Join us for From Service to Advocacy, the Alex Raby podcast, turning legal challenges into empowered solutions.
Welcome to From Service to Advocacy, the Alex Raby podcast. I'm Sam Henninger, and I'm excited to talk to Alex today because we're going to jump in first talking about personal injury cases. Alex, I know that this is a particular expertise of yours. How is it that someone goes about determining the value of a personal injury case, and what factors go into determining the compensation amount?
Well, that is a great question. And I suppose the answer really starts with who's determining that value. So in the case of a case that's not going to court, it's being settled by an insurance company and an attorney, that's going to be very different to a case that's in the courtroom and you're in front of a jury. Obviously, the jury is deciding there versus a claims adjuster with the insurance company. Really, it's about how significant was the injury and what was the impact that had on your life. And then they're going to look at what was the cause of the accident. So, what was let's say if it's a car accident, for example, they'll look at the severity of the crash. That may affect how they value the case as well. And then they're going to look at, what jurisdiction this case happened in, right? Because that will also affect the value of it. If you're in an area where traditionally juries have been very generous, let's say, with their awards to plaintiffs, that will affect how the insurance company will value it versus somewhere where juries are perhaps less generous towards injured persons. So those are all going to be factors that determine the value of the case. But from my perspective, what it's about is making you whole after the accident. Obviously, we can't change what happened, but you do need to be compensated for that. You need to be compensated for your pain and suffering, as well as any other losses to property and so forth.
How is that determined precisely? Do they just come up with a number, or are they set on a certain set of outcomes?
Well, the injured person, the plaintiff, is going to make the request to the jury, and they're going to argue, your attorney is going to argue for why you believe it should be this amount. It's not set by any statute. If you go outside the US, for example, in Canada or in the UK, certain types of injury are actually the award you can get in compensation is going to be limited by a statute. It's going to go up to a certain amount by law. If you, let's say you lost your arm, that's worth X amount, right? So you're not going to recover more than that. In America, in the jury system here, there is no law that works like that. There is no precedent for, well, this person got this amount, so we should argue that it should be that amount, right? It's just looking at the individual circumstances of that case and however you can justify that to the jury. So obviously one of the arguments that commonly you're going to make is whether or not there was a life-changing impact to this person. Some injuries you'll recover from completely in time and with rehabilitation. Other injuries are going to completely change your life. And obviously there's a much greater compensation that's deserved for that. So those are sort of the things that you're going to be talking about with the jury, but it's not predetermined. There's no cap by law or anything like that. It's what can be justified.
As you had mentioned, there are obviously individual cases of varying severity. What is the typical time frame for receiving compensation after an accident, and how does the severity of the injuries affect that process?
Well, that is a question that any personal injury lawyer doesn't like to answer, because we can't predict the future and a lot of things can happen. So if the case isn't going to court, let's say liability of the accident was accepted and we're just talking about, what value should be associated with that claim, and the offer that we're getting from the insurance company is reasonable, and we think it's reasonable, and the client thinks that's reasonable, then we're just talking about how quick to settle it, right? In that scenario that I laid out there, I don't want it to be less than 6 months, right? And in fact, it's sort of a strategy. One thing you can do is just increase the amount of time that you're dealing with this insurance company, right? because the longer it's on their books, the more they want to get rid of it, right? So the offer naturally is going to increase. It doesn't take me very long to pick up the phone and make a counter offer to a damages adjuster at the insurance company. If we demand 50,000 and they say, well, we think 20, I can get back on the phone with them and give them another number fairly quickly. But typically we want to wait about 30 days before making that next phone call, right? Because we don't want to give the impression that we're in any hurry to settle this case. We don't want to give them the impression that we're just trying to turn it around on a dime and just collect a check from them. That's not what we're interested in doing. So having patience and letting the attorney draw out the process is actually going to increase what you might stand to get if you were just to rush through the process. So that's when you're dealing strictly with the insurance company or just with adjusters at the insurance company. In an instance where you are going to court, maybe because liability is being disputed, they're saying, not only are we not going to pay you, but it's not our fault at all, right? We're not even the ones responsible. That's going to have to go to court. And when you're doing that, it doesn't take much for that to last a few years, because the legal system is a bureaucratic process and it's not a fast-moving institution either. So let's say everything's going well, you've been in the case 18 months, 2 years, everything's ready to go to court, everybody goes to court, and then the defendant comes up with an issue. Oh, I didn't know about this or that, or we haven't got this information we needed, or I don't have an attorney yet, whatever the case may be. And the judge decides to postpone that hearing. Well, now it could be next year that you're coming back to court. So when those things happen, it can draw out the process, which is why no one really likes to say this is going to take 10 months until it's completely resolved, because you don't know that. So I would say, as a rule of thumb, anywhere from 6 months to 18 months for a reasonable settlement is a reasonable estimate. If you're going to court, though, it could be up to a few years that you're litigating that case.
I can relate to that, and I think a lot of listeners could learn and appreciate that perhaps there's a strategic advantage in drawing things out, as you said, and trusting the attorney to operate with the other side in a way that's most advantageous to you. Because, for instance, my father, actually, he's an attorney at a government agency, and he's quick to tell me, having grown up near Washington, D.C., that fairness and fast, they don't really go together. So when we talk about the bureaucratic nature of the legal system, that's a built-in thing there. And so having somebody that you can trust, your attorney, to navigate it and work it in the best way for you, that I think should be for most people a relief rather than a source of stress. Now, under what circumstances might a personal injury case need to go to court? You had mentioned how perhaps insurance says that it's not even our fault, a case of liability. So what are those more common circumstances when they need to go to court? And then how likely are those cases, have you seen, going to settle before they go to trial?
There's two primary situations where you're going to court, and one is liability is being disputed. So they're saying, this isn't even our fault. You need to sue this other guy that's really responsible. That's one reason to take a case to court. The other reason is obvious, that they're not willing to offer you enough money to settle the case, right? If you feel that, they're just coming in at a very unreasonable offer. Let's say you have a client that has $40,000 worth of medical bills out of the accident, and they're offering $50,000 to settle, right? You're going to take that case to court. You're going to file the lawsuit. That's not enough. Those are the two scenarios. And then just because you've filed the case in the court and you've made the complaint and started the litigation process, that doesn't necessarily mean that client, that plaintiff is going to end up in the courtroom on the stand in a trial, because 90% of the time they're still going to settle the case before having to get there, right? It's just the fact that you've filed the case, you've made the complaint through the court now, as opposed to just dealing directly with the insurance company.
What happens when that deadline is missed?
Well, you don't want to miss that deadline, because if you do, you're kind of out of luck. Whose fault that may be, whose fault the deadline was missed, that's another question, right? If you took your case to an attorney and signed their retainer agreement, and they knew the date of your accident, and you have given them power of attorney, they're your attorney in fact, and they have the authority to settle the case and so forth, and they missed that deadline, well, then that's malpractice, right? So now you can go after them for the money. So you wouldn't be totally out of luck in that scenario if you actually had an attorney. If it's just you on your own and you had an accident a few years ago, or somebody injured you a few years ago doing something else, and you don't raise that claim before the statute of limitations, it's a pretty bright line rule that you're not going to recover anything. It's barred by limitation.
And what is that time frame for the statute of limitation?
3 years in Maryland, so you've got plenty of time.
When it comes to that, there's something called the Personal Injury Protection Insurance, or PIP. When you claim PIP, does that affect your insurance rates? How does that work?
No, it doesn't. So you can claim PIP. What PIP is, for people that don't know, it means personal injury protection. So on your insurance policy in Maryland, it starts around $2,500 of coverage. You can waive it. You may have waived it without even knowing when you renewed your car insurance, for example. There's often a form in there where if you sign that, you're waiving it. They'll give you a discount on your premium. So some people are in that boat. But assuming you didn't do that and you're involved in an accident, that $2,500 that you have in PIP is something that's going to be able to cover $2,500 worth of medical bills or $2,500 worth of missed work, right? If you are unable to go to work and you have lost wages, it'll cover that too. So in answer to your question, it's not going to affect your insurance premiums because that's a no-fault part of your premium, meaning that you can collect that regardless and it's not going to affect your premium at the end of the day.
What options are available for individuals without health insurance to cover medical treatment costs after an accident? And how can the PIP, and there's also something called assignment of benefits, assist in this regard?
That's a great question. Let's talk about the assignment of benefits, or often referred to as an assignment of proceeds. So even if you don't have health insurance and therefore you're thinking, well, I've had this accident, but what can I do? I can't just go and get treatment because I can't afford it. What you can do is contact an attorney. Every attorney, well, I can't say every attorney, but attorneys that do personal injury work have a whole network of providers that they're going to be working with, which are going to be able to provide them the medical services that they need on what's called an assignment of proceeds. So when you go to that clinic for the first time, whether it's a chiropractor or an orthopedic, or whether it's a pain management specialist or something like that, you can sign the assignment of proceeds. And what that means is that when your case settles, or when you get your judgment in court, when you get awarded your compensation, part of your compensation is going to go to that medical provider to cover those medical expenses of which they fronted the cost. So they're basically providing you with that upfront service free, and then you pay them back at the point where you get compensated. So that's another good reason why you should contact an attorney. Even if you don't have health insurance and you're very pessimistic and you're just thinking, oh well, I've been hurt, I can't do anything about it, still contact an attorney, because there are going to be services that we can get for you regardless of what your situation is. The fact of not having health insurance doesn't mean you're not a victim, doesn't mean you're not an injured person that deserves compensation. So you shouldn't sort of just self-select out of being a plaintiff.
I think that's really great, because I'm sure there are people that are self-selecting out because they're unsure of what their options are. And so to follow up with what you just explained, say, for instance, somebody did have personal injury protection coverage, they used it all up, they don't have health insurance. What options are available to them? Does that fall into what you just explained, or maybe you expand on that a bit?
Yeah, I would say, what we've talked about with the PIP and with the assignments of proceeds, those are the two vehicles that we're going to use to get you the treatment that you need, regardless of what your situation is. There are other ways which could be used. I would say they're sort of last resort tools to use. If you're expecting to be compensated for an accident, you can take a loan against that, right? They're not really great rate loans. There's a lot of credit agencies out there that offer that service. I don't endorse any of them, and I don't recommend it unless there's a very, very pressing need for you to go down that route. I don't really recommend it, but I would say that would possibly be a last resort for you.
Okay, that makes sense. Not optimal, but available. So the lesson I'm taking here from this is make sure you are insured properly.
For example, I don't ever advise people go that way, just because I don't think, if you're going to be compensated, you shouldn't need to have to take on debt. Just wait, if that's possible. So I never advise it. I have counseled people that have decided to go that way, but it's never something that I really advise, just because the cost of it is going to eat into, you're going to be paying interest back, right? It's going to eat into your compensation. So if you were expecting $20,000 in compensation after all of the medicals and everything's been paid for and attorney's fees, and you go and take a loan, you might think, well, I could take 10 now, I'll still get 10 from the compensation. It's not going to work like that, right? Because they're going to charge you interest on it. And as we discussed earlier, we don't know how long it's going to be until you actually get compensated, till you get that check in your hand. So if it's a long time, you're paying interest on all of that, you may never see any money after having, and then you've only taken half of what you could have got. So I don't ever recommend it for that reason.
I want to round things off in asking you, how is it that you go about negotiating with insurance companies to make sure that your clients are receiving the maximum compensation for their injuries?
Well, the first sort of part of the process is, in terms of when we're making the demand to them, is putting together the demand package, which we then send to the insurance company. So that's going to include all of your medical records, all of your medical bills, all of your lost wages, and it's going to have a detailed assessment in there of how you were injured. We're also going to attach our letter to that, which is where we're going to start the conversation, start the argument even, regarding your case. There's different schools of thought on this. Some attorneys are just going to send in the medical bills and records and not even take the extra step of sending the letter in to say, hey, these are our reasons for why we're asking for this much. We don't do that. We take a very diligent approach. We'll go through all of your records in detail, no matter how significant the injury is and no matter how big a case it is. We're going to do that same process of going through all of the records in detail to make sure that we understand exactly how it's impacted you, so that we can talk to the insurance adjuster or another attorney more knowledgeably about the case. So having a lot of knowledge about your case is sort of the primary thing that we're going to be doing, right? You can't negotiate effectively if you just have a surface level understanding of, well, this person was hurt, we see they got $10,000 worth of treatment, so we'll call it this. That's not the way we do it. So that's one way in which we're going to maximize how much we're going to get for the client, is by starting the process there. Number two is, well, we sort of mentioned it earlier, and number two is not being in a rush, right? Because whenever you're in a rush to get money, there's going to be a penalty that's associated with that, right? So, for example, if you want a payday loan, for example, and you want it today, well, the interest is going to be exorbitant, right? Because they're exploiting you. They know that you need that money today. Whereas if you took a longer approach and you went to the bank and you went and you filled out the applications and said, I'm going to need X amount in this amount of time, in a few months, we're thinking of doing this, whether it's a home extension or whatever the case may be, it's a totally different rate to getting that payday loan, because you're not going in and saying, I need it right now. It's the same thing when you're dealing with an insurance company and making a demand for compensation. If you get back on the phone with them every week to follow up and say, hey, have you got, made another offer yet? Can you come up? Can you come up? That looks very desperate. So they're going to note that, and they're going to say, well, it seems like this client, this plaintiff, really needs the money now, right? So if we just go up a little bit more, maybe they'll take that, right? Whereas if you stretch it out, saying, well, they're not in a rush to get the money, right? So if they're not in a rush, that means that maybe they're going to take it to court, right? Maybe they're going to file a lawsuit. That's going to affect their thinking. Number 3 is never be afraid to file the lawsuit, right? If you're not getting what you need to get, then file the lawsuit, demand the maximum that's on that policy, and start the discovery process. Because as soon as you switch from, or as soon as the insurance company switches from just having to pay the claims adjuster to now having to pay an attorney to handle the case, totally different cost for them, right? Their offer is going to come up very much higher, much more quickly, because they're now looking out into the future and they're saying, well, if we have to pay the attorneys or even have our attorneys use their time and resources on this case over the next year, here's what it's going to cost us, right? So let's try and give ourselves a discount and give you a higher offer sooner. So those are the 3 ways you're sort of doing it. It's taking the time and having the diligence of learning the case and learning all the nuances of it and what that client's specific experience may have been. And it's taking your time with it as well and filing the lawsuit if that's what you have to do.
Thank you so much. That was a great explanation. This has been From Service to Advocacy, the Alex Raby podcast. I'm Sam Henninger. Remember to like, share, and subscribe because we'll continue to have great conversations just like this. Thank you, Alex.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.